If you've attended any legal conference in the last couple of years, no doubt there's been at least one session on the ethical use of social media. It's a topic that we talk about just about every conference I go to, and certainly there's plenty of online CLEs too. And I've also met people who say, well, I don't need those classes because I don't use social media. And that's great. That's great if you honestly think that you don't need to know anything about social media. I completely disagree with you. Even if you don't intend to use it, you probably should know how it works, what goes on it, and the biggest pitfalls, because those things are bound to creep into your practice in some way. Because even if you don't use it, your clients probably do. In fact, I would bet money that they do. And so do your opposing counsel, jurors, even judges. So you need to know what can go wrong. So before you jump in and take one of those social media courses at a conference, I want to share with you some of the horror stories about lawyers and social media, because this actually can be a really fun topic. Sometimes it's useful to know what the stakes are so you can understand why it's so important to learn how to use it properly. One of the biggest cases that we talk about in social media and legal ethics is what I refer to as the I Love Hot Moms case. In that case, a lawyer in Virginia was representing a young widower whose wife had been killed by a cement truck. In the wrongful death action, he was seeking significant damages, and in fact, he received a huge judgment, which was later slashed and then reinstated on appeal. But his lawyer was the cause of a lot of the trouble in that case. The client had some pictures on his Facebook which did not make him look like a grieving widower. He was out partying, and his t-shirt said, "I love hot moms." Well, the lawyer didn't like how this looked, and so he had his paralegal instruct the client to delete his Facebook posts. In fact, he deleted the whole account, and they represented to the other side in discovery that the client never had a Facebook account. Well, as you can imagine, spoliation of evidence, lying to the other side, having all kinds of ethical problems in there. Yes, the lawyer suffered greatly. He ended up with a 5-year suspension, which is crazy long. In some states, including California, you won't see a suspension that long because there's a general rule that if it were to warrant that long of a suspension, then your conduct actually warrants disbarment. And so we see that lawyer disbarred in a lot of states. But he had a 5-year suspension and a fine of hundreds of thousands of dollars. And then there's less egregious conduct, like responding to a negative online review. Well, a lawyer in Illinois did that, and in so doing, disclosed client confidences. The client had come to her with a case that she knew he couldn't win, and she told him that. You're not going to win this case. You're not going to get any money for wrongful termination. And he said, well, I want you to take the case anyway. I want to try. So for a $1,500 fee, she tried. They lost. He left her a bad online review, and she wrote back on Avvo, publicly available for the world to see, well, you punched your coworker and I couldn't help you get your benefits. Totally violated attorney-client confidentiality and ended up with a public reprimand. More than that, when you Google her name, that's what comes up instead of her law firm website and all the positive reviews she could probably get from her satisfied customers. Now, one of my favorites also comes out of Illinois. Is there something in the water? I don't think so. But another attorney in Illinois was a criminal defense lawyer, and she posted talking all about her client. In talking about his case, she disclosed that he had been dealing drugs and was taking the rap for his brother, and said that even though he was in college, clearly an education doesn't make you smart. And one of my favorite stories of lawyers on social media was one who went to the judge and said, I need a continuance, I can't be there, my father has died. And just so that's terrible, and granted the continuance. Only she then went on Facebook and posted pictures that she was actually on vacation partying. Judge didn't like that very much. He withdrew the continuance, and she was in a lot of trouble. Even just expressing your opinion, your honestly held good faith opinion on Facebook can be a problem. There was a lawyer in Florida who called the judge in one of his cases an evil witch on Facebook. He was reprimanded. Obviously, these are all stories of attorneys who went online and purposely posted on social media And if you are never going to have a social media account and you are never going to post online, these stories may not hit home for you. But keep in mind, your opposing counsel is on social media, and so are jurors, and so are clients. And even if you would never post any of these things, the people around you just might. And it's very important that you understand that they're doing it, the posts are out there, and you need to know how to look in the accounts and see what's done. And you need to know what to do with those posts if you do find evidence like these.